Hi, I'm Dan Chambers, the founder of Chambers Law Firm. I'm doing a series of videos on new laws that are taking effect January 1st in California that are going to profoundly affect felony sentencing, gang crimes, mitigating evidence to get lower sentences, and a whole host of other changes that could affect your criminal case if you're facing charges right now. In this particular video, I'm going to talk about some important changes that are being made for you to argue at sentencing that you should be given what is called a lower or low-term sentence. Now, in another video, I discussed the concept of a triad, where a felony has three different sentencing ranges. We used the example of an assault with a deadly weapon, where it's a 2, 3, or 4-year felony with the low, mid, and high term corresponding to those. As of January 1st, the judge, in certain circumstances, if you can prove it to them, will be required to sentence you to the low term. So in my example, that would be 2 years. And the judge is now being given additional circumstances to justify giving you the low term. Let me give you a practical example of how this works. Let's say that you were accused and convicted by a jury of assault with a deadly weapon on your stepfather, and the sentencing range for that is 2, 3, or 4 years. Under the new laws, one of the ways that you can argue for a mitigated or lower sentence to 2 years is by showing a prior history of psychological or sexual trauma in your past that's related to the crime. So let's say that you can then argue at sentencing, or if it came out at trial, that your stepfather actually physically abused you when you were growing up, and that was a contributing factor to you committing the crime you committed against your stepfather. The judge is going to be required to sentence you to the lower term of 2 years based upon your prior victimization or your prior history of psychological or physical abuse. Now, there's a bunch of other additional things that are being added to the penal code that you can use to go in and argue for a lower sentence. I'm only giving you the most probably common example that will be used as this law gets rolled out. So, if you think it might apply to your case, please give us a call here at Chambers Law Firm. We'll be happy to talk about your specific situation, and we'll walk you through whether or not you have any circumstances in mitigation to argue for a lower sentence should you be convicted. Thank you.